And so we do, have legal aid at work presenting today. And so I just want to introduce you to Natalie Gottschalk, who's the Work and Family Program Advocate, and also Julia Parish, who is the Senior Staff Attorney. We do appreciate you folks being here with us today. Thank you for joining us.
Thank you, Catherine. Hi, everyone. Thank you so much for joining us. I'm Natalia, pronouns they, them, or she, hers, and I'm like Catherine mentioned, the Work and Family Program Advocate. We're going to be talking about workplace rights for California families. So we're going to start off with a video.
My life has always been a roller coaster. It has its ups and downs. But if anyone asks how I'm doing, I reply, I can't complain. It could be worse. When I was admitted to the hospital to give birth, it started out as a regular process, but I ended up needing a C-section. After I woke up from the surgery, my son turned blue and was rushed to neonatal intensive care. I got to hold him for less than a minute. He spent 2 whole days away from me. Not long after he was born, I got sick with a fever and was rushed to the ER. They think it was my kidneys, but I never got a concrete answer. Then, when my son was 3 months old, my mother passed away. I thought, I guess it is worse. I love my job, but I needed time to get my mind right, so I was referred to a therapist. Later, when I called my boss to tell him I got the okay from my doctor to return to work, he replied, "You took too long." They wouldn't let me return to my job site, but instead had to interview for different jobs with different schedules and different employees from those who I supervised and shared a rapport with. HR told me they only had to hold my job for 120 days. That wasn't true. My job security, my only means to provide for my children, was gone. Sometimes I sit and ask myself, what if I never got pregnant? What if my son wasn't in the ICU? What if my mom didn't pass? What if I never got sick? What if I just gone back to work when they wanted me to? Maybe they would have given me my position back. Maybe I would have never suffered from postpartum depression. Maybe I would still have health insurance and could continue therapy. Well, it was pure serendipity when I spoke with a legal advocate. Although the process was long, the people who worked on my case had my best interests at heart. They heard me out, let me speak, and got some results. I went from feeling lost to feeling a great accomplishment. I am forever grateful to have found their help.
Thank you for watching that. And please feel free to share any reactions or comments or any thoughts that you have in the chat. Um, so a bit of context about Legal Aid at Work. We're a nonprofit organization that provides support with employment law. We're founded in 1916. We do have a number of different services, including educational tools. We provide litigation. We have clinics and helplines. We also do a lot of work in the policy advocacy field, and we also provide direct representation for clients. This is a list of all the different teams that we have under Legal Aid at Work. And you can see here a screenshot of our website where we have all of our different resources available for free. Here's just some of our success stories. Shani was another client that we worked with who experienced a lack of lactation accommodations at work. We also have this photo from our policy advocacy work and some information as well about other policy work that we've done. So why is leave and accommodations important? It's really important for everyone, for the whole family, right? Parents can maintain their job, maintain that economic security. It expands childcare roles to all genders. There's also benefits for the person who is pregnant throughout the whole pregnancy and after. There's decreased stress and anxiety if this person isn't worrying about keeping their job or keeping their income, decreased risk of depression, including postpartum depression. And of course, it's really beneficial for the children with job security and economic security. There's lower risk of preterm delivery or low birth weight for babies. There's increased time for breastfeeding parents to breastfeed their children, increased time for parents to take their kids to necessary immunizations or preventative care, and just more time for bonding is improved bonding for everyone. I'll pass it over to Julia.
Thanks, Natalia. Thanks for that intro. So you sort of may have heard in Delina's story, there's lots of different pieces to the puzzle to be able to access leave and pay and accommodations and sort of have the ability to experience all those benefits that Natalia talked about. And of course, there are many more barriers to access that workers who are paid low wages face. But because the laws are kind of categorized into these buckets, we're going to talk about them as separate things, which is something that's hard for most people to understand. And we don't expect you all to sort of come away with an intricate knowledge of exactly how all these programs work, but that they are different and sort of generally how they go together. And so job protected time off is important because employees can be fired at any time for any reason at all or for no reason, as long as it's not sort of expressly prohibited. And so if someone is going to miss work, we really want to make sure that we have them fit into this job protection category, meaning that they get to go back to their same schedule, their same pay. They're not all of a sudden working on the night shift. And so can you go back actually 1 second? Thanks. And then job protected time off work is one thing, but people also need access to income replacement. They need income while they're not working. Employers are almost never required to pay someone who isn't working. There's like one exception to that. And so California has a couple of state programs that provide income while folks are not able to work, either because of their own condition or because they're bonding with a new child or caring for somebody who's seriously ill. And then we also are going to talk about discrimination protections and accommodations at the workplace. I'm ready. It's paid sick days. Kelly has a question in the chat. What's the exception where employers have to pay paid sick days, or if you're donating bone marrow, or if you have a union contract that requires it? But most workers do not have those things. So if you walk away with one thing, we really hope that these are two separate concepts. Job protected time off is one right, and income replacement is a distinct right. And they both exist in separate systems. And this gets people really confused. They think if they've accessed the income replacement from the state, then their jobs are protected. And that's not how it works. And they think that if they have given the stuff to their employer, then they're going to end up with income. And again, that unfortunately is not how the system is set up. So these are two separate things. And the individual who needs leave has to do both processes separately. So we're going to start off with pregnancy disability leave. California has really strong protections for pregnant workers. And anybody who works for an employer with at least 5 employees is covered by this law. And this says that you can have up to 4 months of job protected time off if you are disabled by pregnancy, childbirth, or related condition. It doesn't mean that you automatically get 4 months. And the reason is because it's sort of individually tailored to the pregnant individual's medical needs. A pregnancy that has without complications is sort of considered, the worker is considered disabled starting at 36 weeks gestation, and then recovered 6 weeks after delivery if it's a vaginal birth, and 8 weeks after delivery if it's a cesarean. But those dates are obviously they can change based on someone's medical needs. So that can be extended so that someone can start leave before 36 weeks if they need to, and they can continue leave after their baby is 6 weeks old if they still have recovery. You can also use this leave intermittently. So sometimes folks have a condition early in pregnancy that resolves, and then they can go back to work, and then they take leave again. Or sometimes people need to use this leave as like a part-time schedule to go from full-time to part-time. All of those are different ways that this leave can be structured. You can also use it for doctor's appointments for prenatal care. This, because we're talking about job protected leave, this is something you ask your employer for. They need to continue your health benefits if they offer you health benefits while you are out on leave. And even though it's called pregnancy disability leave, it does continue after birth. So this is for any condition that is related to pregnancy or childbirth. So a miscarriage is related to pregnancy, right? Postpartum depression is related to pregnancy and childbirth. Lactation is a condition that is related to pregnancy. So like it covers kind of all of these varieties of conditions, even though the name is like a little misleading. People think it stops when the pregnancy stops, but it doesn't work that way. So now there's a quiz. I used to be a high school teacher, so pop quiz for everyone. And I think we can do a poll here, but what do you all think? Are undocumented workers entitled to paid family leave and or state disability insurance? Let us know what you think. It's really low stakes. If you don't get it wrong, there's no consequence. Does everybody vote? Last chance. Okay. We have 2/3 of you thinking that it's true and 1/3 thinking that it's false. Undocumented workers are entitled to paid family leave and state disability insurance. This is true. And you all scored much better than, most people on that question. Around like 2% of people tend to get that question right. So it's very different than other kinds of wage replacement programs, like any kind of federal benefits or even unemployment insurance. And so people often get confused, but paid family leave and disability insurance are available to workers regardless of documentation status. So we're going to talk about that next. So when somebody is out on pregnancy disability leave, they have their job protected because they told their employer, I'm pregnant, I need time off. Maybe they turn in a doctor's note that says, Julia's pregnant, she needs leave from this state to this state. How am I going to get income during that time, right? Okay, they have to save my job for me, but I need to get paid. You have to apply for the wage replacement program from the Employment Development Department, which is the EDD. It's a state agency that runs these programs. And what state disability insurance provides partial wage replacement if you have a condition that makes you unable to work. So pregnancy is one of the conditions that counts, but it also covers a vast variety of other conditions, right? Cancer or, a broken leg. Lots of different things can kind of qualify for disability insurance. And this will run the same period of time that your doctor says you're disabled. So typically it'll start at 36 weeks and go for 6 weeks after delivery. If you have vaginal delivery, 8 weeks for cesarean. But again, those dates can be adjusted by a healthcare provider. Like if somebody needs to start earlier or go later, they can do that. And folks are eligible if they have paid into the state disability insurance fund, which is an automatic paycheck deduction for almost everyone who receives a paycheck. Government workers actually pay into a slightly different fund, but virtually every private sector worker pays into this fund. And right now it replaces 60% of people's gross earnings. And it looks at a whole year's worth of your earnings, and it will choose the quarter with the greatest earnings in it and then give you 60% of that. It feels like a little bit more than 60% because it doesn't have the typical paycheck deductions that paychecks normally have. Some people will qualify for 70%, but those are very, very low wage workers. But the good news is that because of years of policy advocacy by including folks at First Five and lots of other partners, is that the wage replacement rate is going to go up soon to 90% for most workers in California. And so that we hope is going to make a real difference to make this sort of a more equitable program. Right now, the current cap is around $1,600 a week. So it's a much higher cap than other kinds of benefits as well. And as we talked about before, citizenship, immigration status do not affect eligibility. I see a question here that if somebody is undocumented and get paid under the table, can they still qualify? So I assume that getting paid under the table means being paid in cash. And cash, the answer is no, because you have to prove that you've contributed to the fund, and folks who are paid in cash are typically not contributing to the fund. There is a way to do it that is very kind of time consuming because employers are still supposed to sort of make this happen. So if that is the issue for someone and they want to try to claim the benefits, that's a good time to reach out for us for some technical assistance. But if you just sort of submit an application to the EDD, they're going to reject you because they're going to say, we looked and we don't find a wage history for you. So you can work to prove that you have a wage history to them so that you can access the benefits. But it's sort of not a very straightforward path. Yeah, so that is state disability insurance. Maybe some of you have seen that red form that folks have to sign and submit. And yeah, go ahead. Sorry, next. There's either a paper form that has like those red boxes on it, or folks can apply online. You can submit the application sort of like up to 49 days after your leave started, and it will automatically be processed. If it's later than that, you have to just explain the reason that you were late and show that you had a good reason for doing that. And healthcare providers do need to sign to certify a disability form. So this is a little table to show how it all works together. And you can see above the line, it says state disability insurance, and that's where people's money is coming from. That's the income replacement. Below the line is where the job protection is coming from, and that's from the pregnancy disability leave laws. And so ideally they work together at the same time and people are getting both job protection and wage replacement. But as we've discussed, there are some gaps in that, right? Like if somebody doesn't qualify for income replacement because of some reason, or maybe they don't qualify for job protection if they're the only employee, but they could still get wage replacements. So it's not a perfect fit, but most of the time this is how it would fit together. And this is for a pregnancy without complications. But as we discussed, if there is a health condition that requires more time, folks can have more time. The other thing that's confusing to people about this pre-birth time is you don't get to add it to your post-birth time if you don't use it, right? If I think, oh, instead of using that 4 weeks before my due date, I'm going to work right up to my due date, and then I'm going to add those 4 weeks to the end. It doesn't work that way because recovery time is recovery time from birth. And typically that doesn't change regardless of whether you took time off before birth or not, right? Like, so if somebody has their baby's born early, their baby was born at 35 weeks, they didn't ever start their leave, they don't get that extra 4 weeks at the end. They get the 6 weeks to recover from birth. And that's how it is, because it's really tied to the actual health condition. So California is unique in this. In other states, there is incentive to work closer to your due date because you'll get more time off, but it doesn't work like that in California. Okay, so we were going to talk about Lena. I'll read this aloud in case you can't see the slide, but Lena is pregnant and she works as a cashier at a grocery store. Her physician puts her on bed rest at 34 weeks for her high-risk pregnancy. So can Lena access time off and pay? What do you all think? Oops, we're going to do the poll in 1 second. What do you think? What do you think about Lena? She's 34 weeks pregnant. She works as a cashier at a grocery store.
I think she qualifies because her physician put her on bed rest. And so it's, for her health. And she's 34 weeks. So she's about maybe 4 weeks out to possibly having the baby. So I think that she can access the pay.
Any other folks have thoughts? Thanks, Kat.
No problem.
I think the fact also that she's high risk pregnancy.
Yeah, she has a health condition, right? That her doctor says we need to do something about this and start your leave. So typically in a pregnancy without complications, leave would start at 36 weeks. So she needs her leave to start a little bit earlier. And so, yeah, let's go to the next one. What does she have to do as a practical matter in order to make sure her job is protected and to get her leave? Does she just not show up to work one day? So here's our answer. Yes, because Lena's employer has at least 5 employees. She can take leave under pregnancy disability leave. And because she is disabled from working, she can get income through state disability insurance. How does she do both of those things? What does she need to do?
I would say get documentation from the doctor and then apply.
And where does she give the documentation from her doctor?
Maybe on the website of the state of disability insurance or under some type of forms on the website.
Yeah, so remember there's 2 separate processes, right? There's the concept of income replacement and then the concept of job protection. For job protection, she has to communicate directly with her employer. She has to say, I have this health condition, and maybe it's sudden, like maybe it's like that day that she goes to the doctor's office, right? And she didn't give them notice. She has to communicate with them. Just say, I need leave. Here's a note from my doctor that says I need leave because of my pregnancy. That's how she gets her job protected. And then separately, she needs to apply to the EDD, the Employment Development Department, for state disability insurance. And then her doctor will either need to sign the paper form, or if she does it online, there's like a code that the doctors use to certify the claim. But she has to do both of those steps in order to both protect her job and get the benefits. And oftentimes people will only do one or the other because they think in their mind that they have done everything they need to. And of course that would make sense. That would be better. But it's not the way that it is. So people have to do both. Okay, now we have a second quiz. You didn't think we were gonna make you work so hard this morning. So true or false? All workers are entitled to leave, job protected leave, under the FMLA, Family Medical Leave Act, or the state version of the FMLA, which is called the California Family Rights Act, for baby bonding. True or false? Everybody can take job protected leave for baby bonding. Okay. We have a close call again. 60% think, oh, am I sharing the results? 60% think it's true and 40% think it's false. The answer is actually false. For these laws, they're actually pretty strict eligibility requirements. The federal FMLA, which we're not going to talk about, and the reason we don't talk about it is because the state version is better, and Natalia would get into that. But under the federal law, you have to work for an employer that has at least 50 employees to qualify. And that excludes over 40% of the workforce, which means that like on a national level, at least 40% of workers don't have a single day of even unpaid time off for baby bonding. We've worked hard in California to make that different, but it's not automatic for everyone. And again, this is a place where people get confused and sort of fall into traps. So I'm gonna let Natalia take it away.
Thanks, Julia. Yeah, so I'll be talking about the California Family Rights Act. These are the protections in California for job protected time off. And so this law allows workers to take up to 12 weeks of job protected unpaid leave. They can use this for bonding with a new child, including a foster or adoptive child. It can also be used for caring for a seriously ill family member, recovering for someone's own illness, or dealing with certain military deployments. And like Julia had mentioned, folks are eligible if they have worked for their employer for a full year and 1,250 hours worked within that year before they take the leave, and if the employer has 5 employees or more. And for a parent who gives birth, the 12 weeks of leave doesn't begin until after they've recovered from any sort of childbirth or pregnancy related disability or condition. But that being said, the CFRA protects up to 4 months maximum of child or pregnancy related disability time off. And so under the California Family Rights Act, they define a family member as a parent, a parent-in-law, a spouse, a registered domestic partner, child, grandparent, grandchild, sibling, or designated person, which really just means a chosen family member, someone like a neighbor, a friend, an unmarried or unregistered partner, someone who feels like family but maybe isn't family by blood or legally. These are all the different family members that folks can take time off work to care for. And CFRA defines seriously ill as an illness, an injury, an impairment, or a physical or mental condition that involves inpatient care or continued treatment by a medical professional. And so for the income replacement during the CFRA leave, there's a program called Paid Family Leave. It's also administered by the EDD, and it provides partial wage replacement for bonding with a new child or for caring for a seriously ill family member. Folks are eligible if they've paid into the SDI fund through their paycheck deductions, and if they experience wage loss because they're taking leave to bond with a child or to caregive for a family member. Similar to SDI, it replaces 60% of income for most workers and 70% for the lowest earners, with a cap of 1,620 a week. But also like SDI, in January of 2025, thanks to the policy advocacy, it's going to go up to 90% for most workers. There's no waiting period and it lasts for 8 weeks maximum. Again, citizenship and immigration status don't affect eligibility for paid family leave, and it can be taken intermittently. It doesn't need to be taken all at once. But if it is taken for bonding leave, it has to be taken within a year of the child's birth or the child's placement in the home. And so the family member and seriously ill definitions are similar to CFRA, but the one difference with the family member definition is that paid family leave does not include a designated person or a chosen family member. Though we are advocating for AB 518 that would add chosen family to paid family leave, although it won't be up for a vote this session. And then the seriously ill definition for paid family leave is the same as CFRA: illness, injury, impairment, or physical or mental condition that's involving inpatient care or continued treatment by a medical professional. The application for PFL is, again, very similar to STI. You can apply online through the EDD website, edd.ca.gov, or there's a paper application that can be sent in by mail. And workers can apply for this benefit up to 41 days retroactively, or later than that if they present a good cause. And there's no medical certification required if parents are taking time off or if workers are taking time off to bond with a new child, but there is a medical certification required to care for a sick family member, and it would come from the medical provider that's caring for the family member. And so, like we mentioned, undocumented workers would have to follow a slightly different process to apply for SDI or PFL. And we have a guide on our website in a number of different languages that goes through this process step by step to explain to any undocumented workers who might be needing these benefits how to request paper application, how to complete the application, how to follow up with EDD, and ultimately receive their benefits. So we're going to go into our first breakout room exercise and talk about Eddie. Eddie has a granddaughter who was born prematurely at 24 weeks and is needing to spend some time in the neonatal intensive care unit, or the NICU. Eddie works as a welder for a large construction company, and he's been working full-time for 12 years. So we're going to divide you all into some breakout rooms and ask you to discuss Eddie's situation, whether he can take paid leave, and what steps he would need to do to keep his job safe and to get income during that time. There's some really great sharing in our breakout room. So would anyone like to share what you talked about in your breakout room with the group about Eddie? I'll share Eddie's situation again, just to refresh our memories. Okay. Well, I know my group got the right answer, so maybe I'll just share for for everyone. So yes, Eddie can take paid leave. His granddaughter has a serious health condition and she's requiring care, so he can take up to 12 weeks under the California Family Rights Act. Because he's caring for a seriously ill grandchild, which is one of the family members included in the definition of family member for paid family leave, he can also get income for 8 of those 12 weeks. And so in order to keep his job safe and get paid, he's going to go ahead and give his employer a note stating that he's taking California Family Rights Act leave to care for his grandchild. He'll provide the anticipated start and end date of his leave, and his employer might ask him for a medical certification. And then he's going to apply for paid leave through the EDD. And his granddaughter's healthcare provider is going to have to fill out a certification for Eddie's PFL application with the EDD. I'll pass it back to Juliet.
Thank you. Yeah, we had a lot of really good ideas in our breakout room too. So I appreciate that. Thanks, everyone. So this is back to our 2 key concepts. There's the job protected time off and the income replacement. If we're talking about pregnancy and childbirth, right, then people are going to get some pregnancy disability leave and disability insurance. Because remember, disability insurance is for your own health condition, and then paid family leave is for when you're caring for somebody else, either to bond or because they are seriously ill. And then for baby bonding or for caring for a seriously ill family member, then there's up to 12 weeks of job protected leave. And then during 8 of those weeks, hopefully folks can get income replacement from the EDD in the form of paid family leave. And so this is how it fits together for a parent who gives birth in a sort of pregnancy that didn't have complications. So they had the absolute textbook dates for their leave. And so this person started pregnancy disability leave 4 weeks before their due date. They gave birth exactly on their due date, and then 6 weeks to recover from a vaginal delivery. And during that whole time, their job is protected by pregnancy disability leave. And then during that whole time as well, they've applied for state disability insurance from the EDD, and they're going to get wage replacement from the EDD. You'll notice that on this slide it says 1 week waiting period plus 9 weeks, and that's because when you apply for a disability insurance benefits, the first week is unpaid. They call it a waiting period, but it's sort of like they just make you endure 1 unpaid week before the benefits will start. And then after they've recovered from childbirth, which I'm sure everyone who has given birth feels totally recovered after 6 weeks. I did not, but that's when the law said I recovered. And so that's when the bonding leave starts. So the 12 weeks to bond starts after you've recovered from childbirth. Like, notice it does not start the date the baby's born, even though the baby's there. And it does not start the date that my leave starts. It starts after I have recovered from childbirth. And this is something that, again, is very unique to California. and that people often really get confused. They think, oh, the baby's here, my 12 weeks starts. Or they think, oh, the leave has started, my 12 weeks starts. But it actually does not start until after you have recovered from your pregnancy disability. And this includes if your pregnancy disability gets extended, like if, at my 6-week checkup, my doctor says, no, you have an infection, you need 3 more weeks. Then I would have 3 more weeks of disability leave and pregnancy disability leave, and then my bonding leave would start. So these dates can adjust sort of, again, depending on people's health conditions. And then for the wage replacement part, notice that although the job protected time off will last for 12 weeks, paid family leave is at this point 8 weeks, which again is better than it was. It used to be 6 weeks. 8 weeks is better, but still not quite 12. So this is a chart, and we have this chart, actually, Natalia will go over our materials at the end, but we have this chart at the bottom of like our fact sheets and everything as like kind of a helpful reference point for people if they need to look at it later on. So this is, again, the same chart, but for a parent who does not give birth. And when we say non-birthing parent here, I don't mean not a biological parent. I mean a parent who does not like physically push a baby out of their body. And so that can be a dad, a same-sex partner, an adoptive or foster parent. But it's just somebody who does not actually give birth. And so notice that it's the same chart, it just doesn't have that pregnancy disability part, because they are entitled to bonding leave to bond with their new child, up to 12 weeks of bonding leave, job protected, and then 8 weeks of paid family leave. Because remember, paid family leave is the benefit for when you are caring for someone else or bonding with a new child, versus disabilities for your own condition. So we're back to Lena. Lena's baby is born. 6 weeks after her baby is born, her doctor says, okay, you're medically fine. You are able to return to work. Can she take more leave from work, job protected leave, and can she get pay during that time? What do y'all think?
I think she can take more leave.
That is true. Does anybody want to hazard a guess of what, like, why is this leave different than the leave she was already on? Because like we tend to think, like, as humans, just like, oh, she's taking maternity leave, right? Or parental leave, and it's all one clump, but it's actually 2 legally distinct entitlements. So her pregnancy disability leave is over now. She has to separately qualify for a new and different kind of leave. All right, I'll let you off the hook. The answer is yes. She can take baby bonding leave, and that's the 12 weeks of baby bonding leave. And the reason she can take that leave is because her employer has at least 5 employees. She's been there a year, and she's worked 1,250 hours in the year before her leave starts. So she can qualify for 12 more weeks of leave. But again, is everybody going to meet those requirements? Unfortunately, no, right? If they haven't been at their job a year, or their employer is very, very small, or they work part-time, less than 25 hours a week, then they won't qualify for that additional time off. And it is actually lawful for an employer to say, no, you have to come back now or we're going to fire you. So like it's important to sort of know who qualifies for that time and who doesn't. The other thing to point out about this is, remember, in California, it's 5 or more employees. Federally, it's 50 or more. And the law in California, we only changed a couple of years ago. So there are a whole lot of employers who are covered by this law who do not know that they are. And so people might mistakenly be told they don't qualify for this law because the employer isn't big enough. But in California now, as long as they have 5 employees, people qualify. And I think there's a huge gap in knowledge about that. And then again, because she's bonding with her baby, her disability benefits are over, but she can get 8 weeks of paid family leave during her 12 weeks of time off. And again, what does she need to do? She needs to give her employer a note saying she wants to start her bonding leave. And then she needs to apply for paid family leave. Because in her case, she was already getting disability insurance for pregnancy,
This is gonna be
the
over
Employment
at
Development
10:30.
Department will send her a form for PFL automatically. But some people might have to start a separate application. Like if you didn't give birth, you have to start a separate application for PFL. Okay, we have more examples. So I think we're going to talk, is this the breakout room one? So we're going to break back into our breakout rooms. So take a look at this example and then we're going to talk about what we think. So Etta is pregnant and she's due at the end of next month. Etta and their partner Billy have both worked full-time for over a year for employers with more than 5 employees. What steps will Etta and Billy have to take so they can each take leave? And can Etta and Billy both take leave at the same time? And so this is like just a little wrinkle. Remember, Etta is currently pregnant and Billy is not, and they are both the parents of this child. So they both have rights, but they are slightly different. I'll give you that clue. So in the breakout rooms, we're going to talk about like what steps do Etta and Billy have to take so that they can each take leave, and can Etta and Billy take leave at the same time? Y'all, thank you for the good work in the breakout rooms. Does anybody want to share what they talked about? We already did sharing in the breakout room, so we can go to sort of the answers to this question, which is so Etta and Billy. So Etta is the pregnant person, and they are entitled to pregnancy disability leave. So during that time, they can have job protected time off from pregnancy disability leave. And then after they recover from birth, they get 12 more weeks to bond with baby. And during the pregnancy disability leave, they receive state disability insurance. And then after that is over, they receive 8 weeks of paid family leave to bond. And then Billy is a little bit different because Billy is not pregnant. So they're not going to end up taking or having access to the same amount of time off total, because the pregnant person has time that's specifically related to pregnancy and childbirth. But Billy is a parent who did not give birth, and therefore can take 12 weeks of job protected time off to bond with new baby, and during that time can apply for paid family leave from the EDD and get income replacement during 8 of those weeks. And then the answer to whether they can both take time off at the same time to bond with the baby, the answer is yes. Parents can take time off at the same time to bond with baby if they both want to be there. Sometimes people structure it this way. Sometimes people stagger it and they do one and then the other based on childcare needs. But you are allowed to both bond with the baby at the same time if that's what you want, or different times if that's what you want. Okay, we have one last example, who is Mary, and we're just going to talk about this one as a group. So Mary's foster child is going to come join her home in 2 weeks, and she wants to know what her workplace rights are to bond with her child. So what do folks think? Are foster parents covered by these laws?
Yeah, they should be covered under the California Family Rights Act leave.
And what about paid family leave? Can they get, yes, so yes, they are covered in the California Family Rights Act leave. So that's the 12 weeks to bond. Can they also get paid family leave from the EDD during that time, if they're a foster parent? Yes, they can. Right? We want public policies that support people taking care of children, right? So if somebody's taking care of a child, they generally have access to the same kinds of leave. It doesn't matter, like maybe somebody else took PFL to care for the same child at some other point in their life. That's fine, it doesn't matter. So if Mary has been working in her job for at least a year and she's worked 1,250 hours in the year before her leave, and her employer has at least 5 employees, then she can take 12 weeks of leave to bond under the job protected leave laws. During that time, they have to continue her health benefits, and she gets to go back to her same job. Sometimes employers will do funky stuff and try to switch people to like a different location or give them less favorable hours. You're supposed to be able to go back to a job that is basically the same as the one you left, if not exactly the same. And then, yes, Mary can apply for paid family leave at the EDD to have wage replacement during that time.
So I'll talk about some other laws that provide protection for leave or for folks who have children. This is the Family School Partnership Act. And folks are eligible if they work for employees that have 25 employees or more in the same location. And so what this law provides is job protected unpaid leave for a maximum of 40 hours each year. And parents can use this if they need the time to search for or enroll their child in childcare or in school. They can also take this leave to participate in any school activities or childcare activities. And they can also take this leave in case they have an emergency come up, either at the school or with their childcare provider, including an unexpected closure or an unexpected unavailability of the school or of the provider. And except for emergencies, employers can cap this leave at 8 hours per month. It can be used by a parent, a guardian, a step-parent, a foster parent, a grandparent, or a person who stands in loco parentis to a child, which means a person who is acting as a parent to the child. And what the parent needs to do is just request this leave from their employer. The employer doesn't have to provide pay during the leave, but they must keep the job protected for the person who's taking the leave. And then another benefit that Julia briefly mentioned in the beginning was California paid sick days or paid safe days. This is paid time off for someone to take time to care for their own illness, including any preventative or prenatal care doctor visits. They can also take these days to care for a family member who is ill or who's receiving any care, treatment, or a diagnosis. And then survivors of violence, of domestic violence, sexual assault, or stalking can use these paid safe days to go to restraining order court hearings, to relocate, or to meet with their domestic violence counselor and seek services. And these days off are typically available for folks after they've been working for 90 days of employment. And currently, California law requires only 3 days, so employers can cap at 3 days annually. There are a number of cities and like local jurisdictions that have increased these, including like San Francisco, San Diego, some others. And we're actually advocating for SB 616, which is a bill that would require California employees to provide 5 days instead of 3, since 3 is a very small amount of days. And all you need to do is request from your employer. The employer must provide pay for the time off, and they must protect the job for the time off. And so here's another table showing how these laws work together for a caregiver. Just as Julia had mentioned, there's the income replacement, which is paid family leave, and then the job protected time off, which is the California Family Rights Act. 12 weeks of time to provide that care that can be taken intermittently or all at once, depending on the needs of the person that needs the care. And then 8 of those weeks would be receiving pay or income replacement through paid family leave through the EDD. So we have another example to kind of show how this works. This is Clara. Clara's neighbor Jesse was in a serious car accident, and Jesse doesn't have any family nearby who can help him with his recovery. He's going to need some help after his accident with daily activities and household chores. And then he's also going to need to be driven to his physical therapy appointments twice a week. So Clara, who is CFRA eligible, she stepped in to care for her neighbor Jesse. And so if folks would like to discuss, can Clara take leave to care for Jessie? What sort of protections does she have access to? It's not a breakout room, it's just a group discussion, so feel free to unmute yourself.
I think this is gonna be challenging just because they're not related.
Mm-hmm.
I'm trying to think of.
A good point. Yeah, they're not related.
Would she have to take sick time off?
That's an option. Yeah, she can use her paid sick days if she has them to care for him. Any other ideas? Okay. So yeah, so she can actually request CFRA leave as well, so she can get that job protected, unpaid up to 12 weeks off from California Family Rights Act. So in this case for Clara, she's just going to need 2 weeks off to care for him. And then after that, she's going to be taking intermittent time off every Tuesday and Thursday for 8 additional weeks to get him to those physical therapy appointments. She'll be able to keep her health benefits during this time, but you might remember that paid family leave doesn't include a designated person or a chosen family member as part of their definition for family. So Clara actually cannot get paid family leave income during this time that she's taking care of Jessie. If she does want to get some pay, she can use those paid sick days from her employers, which the employer will both protect her job and provide pay, and she can use up to 3 days or more if she lives in one of those local jurisdictions that provides more. But yeah, unless our AB 518 bill passes, hopefully someday, that would add chosen family to paid family leave, and then Clara would be able to get those 8 weeks of paid family leave income replacement to take care of Jessie. Any questions on that? And then these are some other leave laws. Julie had mentioned FMLA, I don't remember what it stands for immediately. I'm so sorry about that. Yeah, but the reason we don't go into depth into FMLA is because it provides the same protections as CFRA, but the California Family Rights Act has slightly more, it expands, the eligibility requirements expand to more workers. There's also the ADA, the Americans with Disability Act, or FEHA, which is the Fair Employment and Housing Act, which can allow for folks to take leave as a reasonable accommodation for a disability. And this is important in case there's a pregnant person whose pregnancy disability is extending past those 4 months maximum that the CFRA leaves. After that, they can use their ADA or FEHA protections to continue to take. Were you going to say something, Julie?
No, I was just gonna say, if you all recall the video of Delina in the beginning, and how her employer told her she stayed out too long and that she only had a certain amount of time. The reason they were wrong was actually because of the ADA. So it is a really important one. Sorry, Natalia, I didn't mean to interrupt you.
Oh, no. Yeah, thank you for sharing that. Yeah, definitely. So this is the laws that protected Delina in that case. There's no tenure hours requirement to qualify. You just have to request from your employer, and it can extend leave beyond the 12 weeks that are covered under CFRA or FMLA. And the employer can deny this type of leave if they can prove that the worker taking the leave is providing an undue hardship on the employer. And then there's also leave laws that protect survivors of domestic violence, sexual assault, and stalking to receive services or go to court or it protects their right to receive reasonable accommodations at their work. And FMLA stands for Family and Medical Leave Act. Sorry about that. So now we have the example of Eric. So Eric just started working at a medical office when he was unfortunately diagnosed with lung cancer and was told that he's going to need to take leave for 2 months for surgery and treatment. So if you'll remember, CFRA protects folks who have been working with their employers for a full year and 1,250 hours before in that year before they leave. So since Eric just started, Does he have the right to any job protection or wage replacement during his leave? And this isn't a breakout room either, so you can just unmute yourself if you have any thoughts.
Because it's medical, I would assume that he does have job protection for sure. They can't fire him or anything like that.
Thank you. Yeah, does anyone else have any thoughts? Okay. So yeah, so to an extent you are right, Kat. So he said, or I'm sorry, it says that he's not worked at his position for a year. He's not eligible for SIFRA leave, but he is, his cancer is considered a disability. So like Kat said, he does have the right to that job protected leave. It would be considered a reasonable accommodation for him to take leave, and he'd be protected under ADA or FEHA. And then because he's taking time off to care for his own disability, he can apply for state disability insurance with the EDD so that he can get that income replacement during the time that he's off from work. All right, and I'll pass it back to Julia.
Thank you. Yeah, that's a really tricky one. And also it's something that employers mess up a lot. Sometimes people think, oh, you're not eligible for FMLA or SIFRA, and they automatically think you're not eligible for leave. But they are required to consider whether disability leave would cover your situation. So like in Eric's example, he hadn't been there for a year yet, so he didn't qualify for SIFRA leave at all. And for Delina, right, maybe which was the video at the beginning, maybe that person has used up all of their SIFRA leave, but they need more. That can also be a reasonable accommodation for disability. So I just wanted to flag that for people. But really quickly, we're going to talk about discrimination protection, because we've been talking about time off and income, but also people should be free from discrimination at their workplace. So employers are prohibited from treating their employees worse because of pregnancy. This applies to sort of all stages of employment: hiring, firing, pay, benefits, promotions. It also means that employer cannot force you to go on leave unless they can sort of prove, unless it's sort of, you can't, well, they can't force you to start leave if you don't want to. It's not like medically advisable for you to do that. And then they can't create a hostile work environment, which is sort of basically harassment because of pregnancy. There's another bill that's going on right now called AB 524 that would protect caregivers from discrimination in employment. And it would help sort of help eliminate, hopefully, the biases that we sometimes see employers making decisions on against people who have family caregiving responsibilities. Next slide. So then the last thing we're going to talk about is accommodations for pregnancy and lactation. Accommodation just means a change to the workplace so that you can do your job still. Okay, so this is our last quiz question. Employers are obligated by law to follow a medical provider's written recommendations. True or false?
True.
It launched the poll. Okay, last chance. Anyone else want to answer? We have one naysayer. Most people think true. One person thinks false. Oops. The answer is actually false. Employers are required to grant reasonable accommodations unless the reasonable accommodation is an undue hardship. But there are circumstances that they don't have to do exactly what the medical provider says. And this is something that almost everyone thinks. They think, oh, my doctor wrote me a note, therefore it has to happen that way. And there are some circumstances where an employer can sort of lawfully say no. And so I just wanted to flag that. That's a good time to reach out to us or refer someone to us if that is happening. But the employer's duty is to provide a reasonable accommodation. It's not necessarily to follow the medical instructions word for word. But the way this relates to pregnancy accommodations is that workers who are affected by pregnancy, childbirth, or a related condition are entitled to accommodations at work. This applies to all employers that have at least 5 employees, and the accommodation must be advised by a healthcare provider. So some examples are maybe someone needs a stool to sit on, or more breaks to test their blood sugar, or a temporary transfer to a less hazardous position. As a practical advice, our advice is to kind of start small, and you can always change an accommodation. Sometimes we see notes that are really, really broad that like eliminate everything that this person does as a job, and that can create complications. So it has to be sort of like medically advisable, and we advise people to talk to their doctors about what their jobs actually entail. And then lactation accommodations have been the law in California for a very long time. There's also been the recent federal improvements to lactation accommodations. So some of you may have heard of the Pump Act. That was a federal law that recently went into effect and has many of the same requirements that the California state law already had, and this was already the law too. People needed a reasonable time to pump. If folks are taking time off that's other than their already provided paid break times, the time can be unpaid by the employer. And there's not a limit to exactly how these pump breaks should work. Like, okay, you get 2 breaks for 20 minutes. And the reason is because it depends on the situation of the person, right? Some people's bodies are different. Some setups and different employers are different. So maybe it takes a long time to walk to the pumping space. Or maybe this person has a very new baby and they need to pump very frequently. And that can change over time. So it's not a prescribed number of times or a prescribed amount of times. It just says it has to be reasonable. And then it's also required that employers provide a clean, private place. It cannot be a bathroom, and there needs to be a surface to put a pump on, access to electricity, a place to store milk, and running water to wash your hands and your parts, your pump parts. And just really briefly, federal employees working in California have different rights. So we've been talking about California rights. And just a trick is that federal employees are subject only to federal laws. So the laws are different, but the federal laws are also improving. And like, again, very recently, there was a federal law, the Pregnant Workers Fairness Act, which gave the right to pregnancy accommodations nationally, which didn't exist nationally, even though it already existed in California. So in general, the federal laws are not as protective. Yeah, so I'm going to pass it back to Natalia.
Thank you. So these are some of our policy advocacy efforts that are that we're working on right now. We mentioned the AB 524, which would protect caregivers from discrimination at work. So we also mentioned AB 518, which would extend paid family leave for chosen or extended family to a designated person. AB 575 has a number of different improvements on paid family leave. And then SB 616 would expand paid sick and safe days to 5 instead of 3. So if anyone's interested in following along our policy advocacy and tracking how these bills are going, you can join our newsletter, the link is available on our website. And along with that, on our website, we have all the different resources that we mentioned. We have a number of different pregnancy and my job resources, the fact sheet that has the graph at the bottom, you can see to the right, that we talked about, which puts all the different laws together and you kind of visualize how they work. There's also a roadmap for pregnant folks and a guide, a very extensive guide for pregnant people to learn all about their different rights to take leave from work. We also have that undocumented workers guide for applying for STI and paid family leave. And we have a number of different resources as well. They're all for free and they're all on our website. And a lot of the information that we talked about during this presentation, we also have in a condensed 7-minute video version, and we have it currently available in 8 languages on our website and on our YouTube, and we included the link in the slides, so you'll receive that as part of the materials. If you want to refresh what you just learned, or if you'd like to share this with anyone that you know or anyone that you work with as well. And that is our website, specifically /WF. That's our work and family team page with all the resources that I mentioned. And then we also have a helpline that you can call for any questions, or if anyone you know or anyone that you work with or yourself are experiencing like any difficulty accessing these rights and these protections, just give us a call at the helpline. We'd love to help you out. And then we also offer these workshops and trainings, and we're happy to organize one in your community if you'd like us to. And there's our information. Does anyone have any questions for us, or anything you can explain again?
You work throughout California or just in the Bay Area?
Throughout California.
And how long does someone have to apply for the disability? Well, after having a baby.
So ideally you apply for disability insurance within 49 days of the first day of your claim. So if you take off 2 weeks before your due date, you would apply within 49 days of that. If people are late, it's usually okay. But our advice is usually to just attach a really brief statement about why the application is late. Like, my employer didn't tell me about this benefit, or I have limited English proficiency, whatever the reason is. And then typically they will approve the late application for good cause, but you have to prove that you have good cause for being late. And I don't know why it's 49 days. What a random number. And you also can't apply early, which a lot of people want to do, but the EDD won't accept an early application. You want to apply after your leave has already started.
Although I will recommend that people set up their EDD account before all of that, because if you are sleep deprived with a new baby, it is really difficult to get through that setting up process.
That is totally true. You can create a login with the EDD and then just not submit the claim until later. That's great advice. And usually if folks are able to, they'll get their benefits faster if they apply online as opposed to paper applications. But paper applications are still accepted and sometimes advisable. You have no questions because we answered everything and it's crystal clear. Well, we hope that you check out the website and the resources and reach out if you or someone you're working with needs help with any of these things. And we really appreciate your time.
Thank you so much, Julia and Natalia, and also Legal Aid at Work for this wonderful presentation and all the information and resources you have for our community. And so just really want to thank you for your time. And for those in the audience out there, we just want to thank you for joining us today. Keep an eye out for an email for a survey after this training. We do appreciate your feedback. And thank you again, and we hope to see you in our future upcoming trainings. Thank you.